Good morning students, welcome to St. Wilfred's online classes. In the furtherance and continuance of the previous lecture, I am going to start with harmonious rule of interpretation, which means where two or more provisions of the statute are repugnant to each other, the courts will try to construe, which basically means is that they are going to try to understand what exactly they mean and so that they can maintain a harmony amongst the two provisions or any two words which they are trying to interpret hereby. Now, a case law regarding to this rule is Rajkrishna versus Binod, whereby under the Registration of Peoples Act 1951, there was a misunderstanding between two sections, which is section 33(2) and section 123(8). The court in this case had come out with a conclusion that if any government servant who wants to nominate a person for the election can also has a right to vote also in the same election. This was the question whether because in one section 33, it was written that any government person can nominate any other person to for the election which he is fighting for, but in section 123(8) it was mentioned that he has a right to vote also. But after the conclusion and the judgment, it was said that if a person is eligible or has a right under a statute to move forward with nominating a second candidate or any other person in the election, he also has a right to vote under the same statute. Now, there are 5 aspects of this rule, which are: first, the courts must try to avoid a head-on clash. The courts must try to avoid any clashes which are amongst two provisions of the same statute. Now, second is, provision 1 cannot be used to defeat or destroy provision 2. No court can use or interpret provision 1 in such a manner that it might invalidate or remove or destroy provision 2 in which it is read with in respect to. Now, the third one is, if impossible. Now, the third aspect of this principle is that if the court finds it impossible to reconcile the differences between the two provisions, it must try to come to as near as possible conclusion and an interpretation so that it does not end up giving injustice or unjust decisions whatsoever. The fourth one is, if it reduces a provision. Now, the fourth aspect of this principle is that if the interpretation of the court comes to a point where any one of the provisions is destroyed or interpreted in such a manner that it makes it useless or dead lumber, then it is not considered to be as harmonious construction. Now, moving forward, we are going to discuss 4 more rules of interpretation, which are: the second one being today is nocitur a socis. Now, nocitur means to know. You must have the knowledge of whatever you are trying to interpret. And the socis means in association with. Basically, in literal sense, this phrase means that any two words which are used besides each other should be read in cognate sense. मतलब they should be read together. उन दोनों का मीनिंग एक साथ समझना चाहिए. Now, for example, in IPC section 498, I'm not going to read the whole section. The section reads, whosoever takes away or entices away any woman. Further in the section, we have used 2 more words, which are any such person conceals or detains with the intent. Now, generally what detention is? Generally, the dictionary meaning of detention is that you are taking away the person against his or her will. Now, under this section, when you are trying to interpret this, when the courts were trying to interpret it, the interpretation which came out to be was that detention under this, when read in reference to takes or entices away, means that detention against or without the will of the husband of the woman who is associated under this section. Now, this is what in nocitur a socis means. Basically, 2 words can be read together and are unmeaningful when not read together, are supposed to be understood and taken इन कॉग्नेट सेंस साथ में पढ़ना जरूरी होता है, जिससे उसको इंटरप्रेट करना हमारे लिए इजी हो जाए. नाउ द थर्ड वन इज ageism general. Now this principle means that a set of words, like for example if we are talking about iron, cobalt, copper, now it is a very layman language में अगर हम समझने की कोशिश करें तो ये सब एक मेटल और हमारे लिए केमिस्ट्री के हिसाब से हमारे जो केमिस्ट्री के हिसाब से हमारे जो साइंस के अंडर हम समझ सकते हैं वो मेटल्स की कैटेगरी के अंडर आते हैं. फॉर एग्जाम्पल इफ यू टॉक अबाउट एनिमल्स, नाउ यू कैन सेग्रीगेट एनिमल्स अंडर डिफरेंट हेडिंग्स, मैमल्स हो गए, रेप्टाइल्स हो गए. उस तरह से कोई भी एक जेनेरिक सेंस में और एक क्लास के अंडर कोई भी वर्ड्स को अगर हम डिवाइड कर सकते हैं और सेग्रीगेट कर सकते हैं तो उनको हम उसी के, you don't have to keep on repeating those words every time under a provision or a statute. Now here what I've written is in generic or general sense belonging to the same gene or class, but this will only be applicable to a place where the words come under the same class or same gene. Now in this particular case, Express Hotel Private Limited versus State of Gujarat, under this case what the question arose was they had filed in the charges for extra charges for electricity, AC, television, room services, etc. Now what the court interpreted is that in this case there was an expression used, expressions and alike, whereby it was made very clear that anything which falls under the same category of being TV appliances, electrical appliances, hairdressers or anything might be chargeable under this law. So that is what was interpreted by the court, that it is very evident and implied that the expression alike means anything which falls under the same category might end up being charged by the hotel, since they fall under the same category and the same class of genes. Now coming to the fourth one is that statutes should be read as a whole. Now what this means is that any statute or any provisions of two statutes must be read together if they are meaningful and they don't ambiguate or they are not repugnant to each other. Now in this case these are basically rules of construction if we segregate them or we classify them as a particular class. So these three, the last three which we are going to discuss fall under rules of construction. Now under this statute the one example is under this case S. Gopal Reddy versus State of Andhra, whereby under Dowry Prohibition Act the court said that under Prohibition Act not only the demand of the dowry before marriage this also should be considered, but the mere demand of dowry before marriage or even the discussion of dowry should be considered as punishable offence under Dowry Prohibition Act 1961. The main focus of this rule is to look into the objective behind the making of law. One person who is interpreting any rule or provision under a statute must know to exactly what objective was there of one law which has come into an existence. Now coming to the last rule which we are going to discuss today, it is Ach re magis vale quem pare. Now in this, if the language of a provision, please take under notice that we are not discussing any particular word or a phrase or anything. We are talking about particular language. If the language of the provision leads to more than one meaning अगर आपको एक ही सेंटेंस से आप 4-5 चीजें इंटरप्रेट कर सकते हो और परसीव कर सकते हो तो आपको द क्लोजेस्ट टू विच प्रोवाइड्स यू जस्टिस को इंटरप्रेट करना पड़ेगा. मतलब अगर आप कोई भी दो चीजों को, आप दो प्रोविजंस भी पढ़ रहे हैं और अगर आपको उनसे 3 चीजें समझ आ रही हैं तो जो भी प्रोविजन या जो भी चीज आपके क्लोजेस्ट पड़ रही है जिससे आप इनजस्ट को रिमूव कर सकते हो और एम्बिग्विटी को रिमूव कर सकते हैं, आपको वो करना पड़ेगा. Now, tomorrow we are further going to deal interpretation of penal statutes, and this completes your second module and the first module we've covered in the previous lectures. We're going to continue with the next lecture tomorrow. Thank you so much.